The problem is he violated the judge's order. You don't get to violate judge's orders. I'm revoking the release, forfeiting the bond. I'm going to set a reasonable bond that I think you should be able to post. But I'm telling you, 10% is the bond. I'm revoking the release and forfeiting the personal bond. And I'm going to give you an earlier court date now than I earlier expressed, because if you can't post, you're entitled to have be arraigned on the charges in the complaint within 1 week. So I'm making.
You perjured yourself on the air. The judge of Howard said that Mr. Rick Johnson was the complainant on the case when she told him she had a black eye, and she went ahead and he pulled the file, and she was a defendant on the case.
I'm going to object to this line of questioning just on the basis that it's not relevant. It's about a prior report, and this is only a bond violation.
Why are we talking about that? This relates to a bond violation that occurred on or after May the 10th.
But she did state on the record, it was brought out by the complainant herself, and which is the next two on here was broken with her character.
Ma'am, this is not for you to decide. I guess I'm not understanding. Can you enlighten me?
It's to her.
Well, I know, but
The truth of her testimony on that part, there's a discrepancy in the truth of her testimony.
because you're saying that Detective Attard will corroborate your client's version and that she was not hurt?
That's what stated in the prior report, so I would have to go and read into that. But the complainant herself is the one that said that Mr. Woods Johnson punched her in the eye. I would like that either stricken because there's no evidence of that.
I have audio.
Wait a minute. Wait, whoa. You can't respond. This, no, I'm sorry. You just can't respond yet. You want to bring in Attard to contradict her testimony, correct?
She's discussing a prior report. I would argue that whatever the.
I don't need to hear anything on that. I'm going to overrule your request, and that's it. Thank you. All right. Do you have any? You can step down, ma'am. Do you have any other witnesses? Do you have any witnesses?
When I'm going to ask a question. I'm not going to ask a question or answer any questions. What I say.
Is he going to be called as a witness, or do you want to just rely on the testimony so far?
Yeah, I don't have anything to say on
But
that.
ask Mr. Woods Johnson, time you have already do the relation in this case, would you like to do that, or would you like to remain silent?
All right. Look, if you want to argue, make it quick.
The complaint indicated not only the there was a no contact order. She indicated that she did see him at the household on May 15th, and she had gone there to photograph the belongings. And she also indicated that she received a text message. In addition,
She got one text message that
Your Honor,
where he loaned her money, right?
in addition to that, Your Honor, I think it's really important for the court to take notice of the CPS allegations and the police contact she has had with him. I understand that you did not believe that to be contact, but the people would argue that that is indirect contact. It is a form of intimidation and a form of harassment. He did that following last.
How do I make the determination that that was a form of harassment when they haven't even concluded their investigation? There's nothing in a no contact order where a judge can preclude somebody from filing a CPS complaint. Now, he may have other issues of that down the road, and it may turn out to be false. And then that's going to hurt him immensely. But I'm not going to rely on that. Here's the bottom. He violated the no contact. He violated the judge's order. The judge told him, or the magistrate lawyer, whoever that is, told him on May the 10th, you're not going back to Matt's Drive. For whatever reason, He chose to ignore the judge's order. That's a problem. That's a big problem. And then I don't care what kind of help you intended to give the victim. When a judge says no contact, they're not kidding. He means no contact. And you had contact with him. It's not a violation of the no contact provision for the victim to have contact with the defendant, but it is for the defendant to have contact with the victim, at least as this order was framed by the judge. Where does your client work?
He works with Amazon, it's Twitter, you have Amazon, he works full time, prior to season is coming up, works with additional hours.
You can't do this. I'll let you guys address bond. What are you asking for?
Your Honor, because of that bond be removed.
No, I would ask for the person bond to continue. There had been no further contact. When this court week appeared on the 19th of May, this court made it very clear not to have any contact. After May 15th, my client lost the telephone number, so he wouldn't answer the phone or have no contact. He was lost his home, moved out at this time.
You can see that on the 19th, I say that he may return to the property at 23652 Mance Drive.
He did.
And I said after 6:30.
And there was no issue.
I know, but here's the problem. I may or may not agree with that judge's order when somebody owns or is the leaseholder of a property and the other side is not. The problem is he violated the judge's order. You don't get to violate judge's orders. I'm revoking the release, forfeiting the bond. I'm going to set a reasonable bond that I think you should be able to post. But I'm telling you, 10,000, 10% is the bond. I'm revoking the release and forfeiting the personal bond. And I'm going to give you an earlier court date now that I earlier expressed, because if you can't post, you're entitled to be arraigned on the charges in the complaint within 1 week. So I'm making it June the 2nd at 9. Again, bond is in the amount of 10,000, 10%. They'll let you make calls if you don't have the money to post it, but you're not going to violate a judge's order. Do we understand
Yes,
one
sir.
another?
Yes, sir.
Good. Don't do it again. Do you have $1,000 to post?
$1,000 today, I can make some phone calls.
They'll let you make phone calls back there, but you're in custody until you can post it. Do not do that. You got me?
Yes, Your Honor.
All right, good luck. Have a seat there. I'm so sorry, Detective, wherever you are. This is Tyler Joseph Bensick, 26W71100. Your name, Detective?
Yeah, Detective Sergeant Beth Freeman at the Woodhaven Police Department.
Raise your right hand. You solemnly swear affirming the penalties of perjury, the testimony you've given these proceedings will be the whole truth, so help you God.
I do.
Okay, go ahead.
Yeah, on April 1st, 2026, at approximately 15:55 hours, Officer Probst took a walk-in larceny complaint. Officer Probst spoke with victim Tammy Bensick in the department interview room. Tammy advised her wedding ring is missing and believes her son, Tyler Bensick, stole it.
I'm having a little hard time, Detective. I don't know if you got to speak directly into the mic or to the device,
Can you hear
but
me better now if I speak up?
yeah, just keep your voice up more.
Okay, Tammy states that she saw her ring on March 30th, 2026 in her nightstand at her residence, which is at 22407 Huntington Court, Woodhaven, Michigan, 48183. The following night on March 31st, she observed the ring to be gone. She stated the drawer looked like it was also gone through because everything was moved around in it. On April 2nd, 2026, I reviewed the case. Victim Tammy Bensick states that her ring was stolen and she believes that her son, Tyler Bensick, committed the theft. Tammy suspected that Tyler sold the ring to a pawn shop. At the time of the call, Tammy was unable to provide any evidence that Tyler was the one who stole the ring. On April 8th, 2026, I spoke with Tammy again via phone call. Tammy informed me that she had spoken with the owner of Flat Rock Exchange, which is a pawn shop. She spoke with worker Joseph Comig. Joseph informed her that Tyler Bensick had pawned 2 of her rings and provided her with a receipt. Receipts showed that Tyler sold 1 ring on March 30th, 2026, which was a 14 karat, 2.7 gram opal gold ring for the amount of $120. Tyler sold an additional ring on March 31st, 2026, which was a 7.3 gram, 14K white gold diamond ring for the amount of $450. Tammy states that both of these rings are hers and she never gave anyone permission to take any of them or sell them. Furthermore, Tammy informed me that she wished to pursue charges against Tyler. On April 8th, 2026, I made contact with Flat Rock Exchange owner Joseph. Joseph confirmed that Tyler Bensick did sell both of the rings to the pawn shop. Joseph provided receipts from the transaction. It should be noted that Tammy recovered her stolen rings from the pawn shop, but had to pay a total of $570 to get them back.
Based on your sworn testimony, I find that the crimes larceny in the building and larceny 200 or more with less than 1,000 were committed. There's probable cause to believe the crimes were committed by the defendant. I'm going to authorize the issuance of the complaint and warrant. Sorry to keep you waiting. I really am. We did not know we were going into that lengthy of a hearing. So my apologies. You're all set. Have a good day. Thank you.
You too.
Calling the prosecutor, please. People against Victor Matevsky. 267-680576.
Prosecutor.
I need the prosecutor in here, please. Mr. Kazmarek. Thank you.
Yes.
Mr. Kazmarek, your name?
Jason Kazmarek on behalf of Mr. Matevsky.
We're going to a formal hearing on this?
That's my client. We were just talking again. He was going to join and maybe go to the hearing by himself, not have me on it, which
Well, where is he? Is he here?
he's joining right now. He was calling in. He should be. He said he was in a waiting room. I don't know if he's in the waiting room.
Is he out there, Lisa?
I had someone by phone,
By phone. He's just phone
but
only.
they've disconnected.
Oh crap. He said all he could hear was I told him to reconnect because he said all I can hear is music. I said, you can't hear the judge? He said no. So he's calling. I told him to call again.
Tell him to call back in. I'm going on to another case
That's
here.
fine.
Will you, please?
That's fine.
Judge, can we
Counsel,
see who's in the jail real quick?
what's your name in the jail there, sir?
Rashid
I
Hussein.
can't hear you.
Can you hear me, Hussein? The last name Hussein?
Hussein?
His first name is Shoot.
Yeah.
Okay,
correct.
got it. Thank you.
Okay, where's Joanna Webster?
All right.
Or Giovanni Webster? I can't do this, counsel. This is 26 D827-974. Where is Giovanni? Oh, you got to take your head off, Mr. Webster, and tell me your name.
Yes. Joe
I didn't hear a word you
Webster.
say it again, if you would, please.
Joe Bonnie.
Okay,
Sorry.
okay, that's okay. I'm sorry. Your name. Okay. So you said defendant has fishing license.
Yes, sir.
Defendant to pay conservation fee of $10. I can't do that. I mean, if you want to dismiss, that's fine, but I can't order costs if somebody's not found guilty of something.
I understand, Your Honor. But I guess the one I would just be discussing that interest of justice and there is a section, Your Honor.
Oh, would you just change that on both of these, please? Sadie, hand her that, please.
So Albert, would you have any?
You could just cross it out and initial it and do the same thing on the other one, on Koreshi. Here you go, Sadie. All right, Mr. Webster, today's good news for you, okay? They can't even, did you have your fishing license then?
No, sir. I was.
You can't fish without a license, right?
Yes.
So she's being awful kind with you. I'm going to go ahead on her motion and dismiss the case. There's not going to be a $10 conservation fee either. So you're all set. Case dismissed.
Thank you,
No
sir.
cost. No cost. Okay, good luck. This is Judge Hudson. So just give me a minute here. So you're back here he's back here for a review hearing, right, Lisa?
That's correct. It's a prosecutor review.
Says victim advocate spoke to complaining witness on May 22, says no issue with closing case out. Complaining witness says they haven't heard from defendant, and complaining witness name is Loretta Iani. People do not object to closing case out. Do you have any other cases pending? You haven't gotten in any trouble since you were sentenced by Judge Hessen back on May the 27th of 25? And you did all your programs, this says. Case dismissed. You still love how they write these up, though, I gotta tell you. They have no objection. But that's okay. Case dismissed, you're all sent. We'll send the paperwork to you, okay? Have a good day. Good luck to you. All right.
Oh,
Come on up here, ma'am. Are you Miss Asciuto? Asciuto, I'm sorry. Haley Maria Asciuto, 2-6M-690162. Good morning to you. How are you? You're prepared to fight this, huh? Case dismissed. The officer will appear. I'm just kidding.
Thank you.
You're all set. I gave you 15 minutes for the record. It was scheduled for 9. It's 9:26. Good luck to you. Please don't do the operating while texting, though, okay? Okay? What's your name, man? Yeah.
Leah Moore.
Leah Moore?
Yes.
Okay, let us see what we can do here, okay? No, just wait right there. You can have a seat. You're fine. You're fine. No, I'm just saying.
it's not till 9:30.
Oh, okay, you can just have a seat. Okay, thanks. What is that scheduled for?
It's an informal 9:30.
I see. Okay. So I give them 15 minutes, okay? So if they're not here by 1:45, I'll dismiss it.
This one here is Judge Hessen, but they said she wasn't here today, so she's just sick.
Oh, okay. How are you? What's your name? Nice to meet you. Okay, so you're gonna shadow with Judge Hessen, right? But she's not here today, so glad to have you. If you want to come back when I take a break, I'll be glad to answer any questions you have, okay? Do you see a Koreshi case on there? QUR, Q.
Oh, yeah, I'm here.
What's that? What's he here for? What's informal? Okay. Yeah. Ms. Holloway, is she on this? Is Ms. Holloway on this?
Yes. Oh, I do, grab it.
Yeah, would you?
Yeah, thank you.
Morning to you. How are you, Ms. Holloway? Your name?
Okay, so bunch of eight.
All right, Ms. Norris, your name again?
Ashley Norris.
Mr. Smith?
Sean Smith, P number 51431.
Mr. Norris?
Brett.
Listen, I know you guys don't like to, I can't just dismiss this based. So you're gonna move to Nolly Pros, correct? You're gonna fill that out hey, Sadie, can you hand her that? Ms. Norris,
Yes.
you don't want to proceed here?
I am okay with dismissal.
That means you don't want to proceed?
No, Your Honor.
Who called the police?
I went to the station.
Okay, so I'm not gonna ask you any more questions. You initiated a complaint.
Yes.
To me, once somebody makes a police report, especially when they initiate the charge, they should go forth with it. I'm not going to make anybody do anything unless they subpoena you and you don't show up. But just recognize that a lot of people did a lot of work on this. Are you with me?
Yes.
So people move to Nolly Pros. I'm going to go ahead and dismiss the case. And Lisa, we're going to make sure we take all the bond conditions out, okay? So that included no contact, no firearms, no weapons, not to enter the property address. So we'll take that out and all those bond conditions are lifted. Thank you, Ms. Holloway.
Thank you.
Case dismissed. Good luck. Thank you both.
Thank you.
Best of luck.
Your Honor.
Thank you.
Just have a question.
Sure.
So I understand that you want people to move to Valley Bus. Would you,
If they don't show, if your witness doesn't show up for trial, that's different. But-
I understand, I mean, so like right now, would you be okay? Would you be okay if I said no objection to the defense's motion to dismiss?
Not on something like this. I don't, do you understand? You're just telling me she's uncooperative. That's fine. It's your case. It's not mine. And I know they don't like to have anything where they're moving to dismiss anything anywhere. But I'm not going to dismiss it because your victim's being uncooperative and doesn't want to proceed. That's up to you guys to Mally Pross. Please don't send them in. I mean, I don't know why it's gone this far. You know, like the last guy, Judge Hessen's case, where I'm saying, you're saying no objection to closed case, or I don't know if you did it or Ms. Ismaro, that's not appropriate. I mean,
I was just wondering what the court was.
no, I know. I'm not getting on you. I think guys take directions from people that,
You know, with all comfort, to be court, this prosecutor is very diligent.
she's a good prosecutor. I'm not complaining about her.
I think justice is.
I'm not complaining about her. She does a good job. But sometimes they take directions from people. And maybe I don't agree with those directions, but that's neither here nor there. Thank you very much. Have a good day.
See you. Thank you.
Jaden Lamont Weber, 26W842606A.
Good morning, Your Honor. Attorney Corey Westmore, appearing on behalf of the Weber. Weber, would you please state your full name for the record?
Jaden Lamar Weber.
What happened?
Aye.
He didn't show up on the 20th.
I was at work. I just started my new job.
Well, did you bother calling anybody at the court and saying, hey, I can't make it today? Can you please reschedule, or did you just skip?
Honestly, it flew right past my head. I gave an estimate to myself in my head when the court did. So I wasn't constant checking. So that.
Just don't let it happen again, okay?
It's okay.
So we're rescheduling this, Lisa. It's a Woodhaven case. So it's in front of Judge Hessen, so this is gonna go on what day? Oh, you might have written it on here. I'm sorry if somebody did. We're gonna reschedule to June 17th at 10. I'm sorry. Reschedule to June 17th at 10. I'll just make a note, defendant appeared today. Okay, so you go down the hall and we cancel the warrant. I'll reinstate the bond. I don't even know if she gave you a bond. Actually, it doesn't look like he was arraigned.
He was.
Does he stand mute, waive formal reading?
That's correct.
Not guilty plea is entered. I'll indicate that he stands mute. And I will go ahead and give you a $100 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed, okay? So you go down the hall, get your notice. And if you want a court-appointed lawyer going forward, you're gonna have to fill out a petition for one, okay? Where do you work at?
Work at Agent Package.
How much do you make?
Like 17 now.
He just started 3 weeks ago.
Kids?
No.
Full-time
Married?
student at Wayne State.
Okay, you fill out your petition. You'll probably,
He did fill
okay,
it.
okay, good enough. Thank you very much. Go
Thank
down and
you.
get your notice. Good luck, sir. Wayne State, what are you studying?
Civil engineer.
Good. Good. Don't miss court dates though. All right. Wait here. More. That's the 9:30.
Yeah.
Here in court is direct. You give me the vehicle while you're texting or. That, I see people all over the road. I mean, it's just, okay. Case dismissed. Have a great day. Thank you. Tillerson. Georgette Elisa Tillerson, 17B1224748.
Good morning, Your Honor. Attorney Corey Westmore, appearing on behalf of Ms. Tillerson. Tillerson, will you please state your full name for the record?
Georgia, illicit solution.
Now, what would make you come in here 8, 9 years after the fact?
Your Honor, she was living in South Dakota. It just got away from her. She thought she had paid it off, paid the ticket.
Where does she live now?
She's living in Hazel Park.
How long you been living in Hazel Park?
I just moved to Hazel Park in that time.
Where'd you move? Where were you living before that?
Sioux Falls, South Dakota.
Did she stand me away from a reading?
That's correct, Judge.
Now, you can't do this. You got $150 with you, right?
Yeah.
$150 cash fine. You cannot leave the state without consent of the court or violate a law. You must appear in the court as directed. I'm gonna ask you to give me your, well, you don't have to do it now, but go down the home. She's gonna post her bond and have you provide your current address to them down there. Okay, the case is gonna be heard on June the 10th at 9:15, and you will be in front of Judge Hessen. Okay. I
Thank you,
believe.
Judge. Have a nice morning.
Yeah, you too. Thank you. Anything else in that here or not? If not, I'm gonna get off the bench.
Nothing right now, Judge. I have a few in with the prosecutor.
Okay, thanks. Come back here. How are you? Walk right through there. Stay seated, everybody.
Quarterback, so. Just seeing.
Yeah, you can sit right there.
Thank you so much.
You know, how you doing there, Mr. Cayley?
Morning, Judge. I'm doing well. How are you?
Good, good. Sorry. Do we have, how you doing?
Let's go outside, make sure it's coming.
Our plan is on the last goes with, I'm gonna put that.
Okay.
Judge, you want to do the signing records for Judge Hessen?
Yeah, I'm gonna do them, but I want to get these lawyers out of here first if.
I'll put those.
Okay. Schneider National Carriers to success 118-143 B and A. Good morning, Mr. Cayley. Your appearance?
Morning, Your Honor. Roger Cayley, P. 48811 on behalf of Schneider National Carriers.
So so there's agreed upon fines and costs on count one overweight, $4,000, and then they're going to dismiss
Count two. That's correct.
count two, right?
That's correct, Judge. I have the
You're
authority to plead responsible on my client's behalf.
I'll accept the plea, $4,000, and they can pay by June the 26th. Okay? Is
Yeah,
that
that's
good?
perfect. 30 days. June 26th, you said, Judge?
Yes, I did. Have a great day. Thanks, and I'm dismissing count two. Thank you.
Thank you.
All right.
Have a great day, Judge.
You too.
Bye-bye.
Bye now. Is there something, hey, Sadie? I don't know. There's something wrong with that. Let me get a chance. All right.
It's just,
Now I've got, pardon?
it was just off. Good.
Okay, thanks. All right, Eric Woods Johnson, 26B710716.
Sorry.
All right, good morning. We're gonna have to get the prosecutor in here. Where's the register of actions? Call the prosecutor in here, please. I'm gonna have to have them find the. I'm gonna have to have them find the register of actions. I don't know where it went. It's not in the file.
Maybe not having us listening.
Well, I'm talking about the register of actions for the file. You know, the cardboard type. Are you on Woods Johnson? Come on up here and tell me your name again, please.
People, P8652
Stucker?
Yeah, please, no, court downtown, there was 359-229, representing Mr. Rich Johnson, that is my left.
Your name?
Eric Woods Johnson.
Somebody's misplaced the register of actions. It's not in the file. Can you check on that and I'll recall it momentarily? I don't know who,
No, I don't, I checked.
it's just, let me call this other case. The People Against Dennis James Ross Jr., 26X, 26M692118. Your name, you have to unmute. There you go. Your name, sir?
Dennis Ross.
I'm going to go ahead and dismiss your case. The officer failed to appear. I gave him 15 minutes. It was scheduled for 9:45. It's now 10:05. You are all set. Case dismissed. Slow down though, will you please?
Thank you, Your Honor.
Have a good day.
Bye-bye.
Thanks. Okay, there you go. Good, thanks. This is not the register of actions. They got to be careful back there. I'm talking about the register that we fill out everything. They've got the criminal history and complaint of violation of conditional bond release.
Looks like this.
Yeah, it looks like that. That's. Yeah,
They must have slipped out.
that's okay. We just got to be careful with that thing. All right, so I'm back on record and I'm Eric Woods Johnson, 26B-710716. I'm going to ask everybody to state their name again, please, for the record. Stand up, Mr. Woods Johnson. Tell me your name.
Eric Woods Johnson.
And Ms. Tucker Davis.
Yeah, please, the sound court, Don Tucker Davis, P59-229, representing Mr. Don Woods Johnson.
Why don't you move over there, Mr. Woods Johnson? Ms. Alloway, your name? We have a potential bond violation. This is going to be a waiver, correct?
That is correct.
I'll take the waiver. We'll address bond before I sign the bind over certificate. Sir, you understand what your lawyer is telling me?
Yes, Judge.
Your lawyers, you have the right to a preliminary examination, but your lawyer is telling me that you're going to waive your right to an exam. There's two counts. Count one, felonious assault, a 4-year felony. Count two, domestic violence, for which you don't have the right to an exam because that's a 93-day misdemeanor. But on the felonious assault, you do have the right to a preliminary exam. And at that exam, the people would have to show that the crime was committed and that you were the one who probably committed the crime. By waiving your right to an exam, you will automatically be waiving that requirement. You will be bound over for further proceedings to the Wayne County Circuit Court. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand this document entitled bind over after preliminary exam / felony?
Yes, Your Honor.
Anybody force you to give up your right to an exam?
No,
You still have to do that.
yes, Your Honor.
Waivers accepted. I'm going to bind you over, but I'm not going to sign the bind over certificate just yet. But your court date will be on June the 9th in the Wayne County Circuit Court. Now let's talk about the bond violation. There's a complaint of violation of conditional release that caused him, I don't know if they arrested him. Did they arrest him, Ms.
On the date of this incident or this case in question?
On the complaint of violation of conditional release?
No.
So you need
That
to,
was sent in the last Tuesday morning to the court. If you recall, that was when myself and Ms. Tucker Davis received it.
And Mr. Wood,
did I address that already?
Yes, and so we set this court date for the hearing.
Well, complaint of violation of conditional release, and I'm going to ask you to look at that. when there's a complaint of violation of conditional release, it permits them to take him right into custody. In other words, if the police were called by the victim and were told that there's a violation of the no contact provision, and they went out to the house because the defendant's still there, they can fill out this form and they can immediately take him into custody. That was not the case here. So the detective really needs to come and swear to an oath and explain what he has. And then the judge, whether it's me or Judge Hessen, are going to get to determine whether or not there's probable cause to believe that the defendant violated the bond condition, or at least by a preponderance of the evidence. So I'm not going to make an issue of it, but if this form, complaint of violation of conditional release, really should only be utilized when they're taking the defendant into custody because they have the basis to believe from their own eyes that he violated the bond. Otherwise, they should come in and do essentially a signing on record and swear under oath as to what happened. Okay? Am I making sense?
So if swearing under oath on the record is the alternative, if they did not take them into custody?
Correct. In this case, it appears to me that she got the victim showed them text messages, right?
Correct.
So they wouldn't have seen him. So now they really should come in and what they could do it on record on Zoom, but they can't. It's fine the way he did it, but they're using the wrong form. They should be testifying in a case like this, as opposed to filling out this complaint of violation of conditional release, which enables them to take the defendant into custody. That being said, I'm going to read it.
Your Honor, the complainant is here. I did, we were prepared to put her on the record. There have been other allegations that she has told me about that I would consider intimidation and harassment that I needed to push.
Is she in here now? Bring her in.
Would you like to begin a hearing then, or we call her in?
Yeah.
Okay, so people will call Alicia Calvin. I will go. The advocate is here. I'll look it up.
You guys can have a seat. Detective Vesprini, are you on this Bensick case?
Yes, Your Honor.
If you want to just bear with me a few minutes, okay? And I'll call it as soon as I'm done with this little hearing.
Okay, no worries.
All right, ma'am, come on up here. Whoever Ms. Calvin is. You can go right there to no, right behind you. Right there. I'm just going to ask you to raise your stage.
With the microphone.
That's a microphone. There you go. It doesn't look like one. I don't blame you for not realizing it's one. Tell me your name if you would.
Asia Calvin.
All right, I'm going to ask you to raise your right hand. You solemnly swear right hand. Solemnly your right hand. That's your left hand.
Right.
It's okay. It's all right. I do that all the time. You solemnly swear or affirm the testimony you'll give in these proceedings will be the whole true self you got.
Yeah.
Don't be nervous. What kind of contact did Mr. Woods Johnson have with you on May the 15th?
He didn't have any contact with me. I returned back to the residence on Mother's Day. My father passed, and I left the residence in a hurry. I left all my stuff behind. And I returned on that day, and when I returned, he was in the home.
Well, on May the 19th, I told him he may return to the property at 23652 Nats Drive, Brownstown, after 6:30 p.m. I think you were still in there at the time. You don't own the residence, but he did this on May the 15th. Is that true?
Yeah, this is beforehand.
Well, counsel, how can this? Hang on one second. Let me check something. I did not do the initial arraignment. It was done out county, I believe. Was there a no contact provision?
Yes.
Yeah.
I was told that he wasn't going to return to the home, so that's why I left my things. I had packed them up. I had put them by the door. I had turned off all the lights, and I had left. It definitely looked like I was leaving. My things were packed when we got rid of them.
Okay, so May the 15th is the date that this occurred, that he came back to the residence? Is that true or false?
I'm not sure the actual day right now.
Your Honor, if you, I can show her,
I have the text message correspondence from when I was in the house. I have audio from when I had came to the house prior to.
When were the text messages between the two of you?
It was the morning right after I had left.
So you got to tell me, you got to be more specific. I have to know dates. What date did you leave there?
Can I get my phone? So I could.
I think we have the numbers as well.
Yes, in my minutes.
The court for, we could have it on the standard, I could ask for.
That's fine. Have a seat over here, ma'am. You're still under oath. Go ahead, Ms. Oliver.
Could you please state your name for the record?
Angel Calvin, sweet.
So, Ms. Calvin. Did something on May 8th bring you to court today? You have to say yes.
Oh, yes.
Do you know somebody by the name of Eric Johnson?
Yeah.
Do you see him in the court today?
Yes.
Could you point to him and tell him the color of his shirt?
What?
Your Honor, please let the record reflect that the witness has identified the defendant.
Record should so reflect.
Asia, are you aware that there is a case open today involving yourself and Eric Johnson?
Yes.
And the case was initiated because of an incident that happened on May 8th, 2026. Do you remember that?
Yes.
And following, well, let me ask you that. On that day, did police arrive?
Yes.
And was he arrested that day? And was the defendant arrested that day?
Yes.
You got to keep your voice up for us, okay?
Following that, were you aware of any type of order made by a court that did not allow the defendant to have contact?
We're speaking in reference to the assault,
No, following the incident in question where the defendant was arrested, were you made aware of any order that did not allow him to have contact?
the police removed him from the residence and told him to not return.
And are you aware of any order that was put in place that?
By a judge. You're shaking your head no?
No.
Are you aware of something called a no contact order?
No, there was no contact with that.
Is that to your knowledge?
Yeah.
Okay. But do you recall the police telling you not to return the?
Yes.
Your Honor, at this time, I would just like the court to take notice that there was no contact.
All you have to find out, listen, did he have any contact with you on or after May the 10th of 2026, either by way of phone call, texting you, emailing you, coming to your home, coming to your place of employment or otherwise?
No, I seen him the day at the house when I came.
You know, what day was that, ma'am?
I'm having a hard time here.
Okay, listen to me. I want you to listen. Just listen to me.
So I need to be able to see my phone to understand which one we're talking about.
Okay.
Over that entire week, the police had been to our home like 5-6 times.
And if I may apologize.
Yes, the incident occurred on May 8th, right?
With the knife, or are we speaking?
The case that we're here on today, ma'am, look at me, please. Just look. The case that we're here on evolves from a May 8th incident of 2026. You're aware of that?
Yes.
Where he's charged with felonious assault and domestic.
Yes.
He was arraigned on the charge on May the 10th of 2026 by a judge out county.
Okay.
The judge laid out conditions like you can't have contact. Wait, just listen. You can't have contact. You can't go to her house. You can't go to the Mats Drive house. So I want to just talk about anything that happened on or after the date of that order of May the 10th. Did he have any contact with you on May the 10th in the evening or thereafter up until today's date of May the 26th?
Yes, when I went to the residence before. When I went to the residence before the court date we had before this, he was at the residence.
What day was that? You can look at your text. You need to look at your phone to refresh your recollection?
Yes.
Okay, go ahead and look at your phone.
It was May 15th.
Okay, what happened on May 15th?
May 15th around 2 o'clock, 2 a.m. Yeah, I went to the residence to retrieve the things that I packed and left by the door. When I left on Mother's Day when my father passed away. When I got to the house, I opened the door and I had came in. Prior to this, Eric had took all the doorknobs and the locks. He took all the doorknobs off all the doors except for one. He took the locks off the doors.
So you appeared there at 2 a.m. to retrieve personal property? Wait a minute, listen to me. Listen. On May the 15th, you returned there at 2 a.m. to retrieve personal property. And he was in the residence. And there was an order for the record from Judge, it looks like, or Magistrate Boyer, I don't know what court he's out of, but at any rate, it was signed May the 10th. Do not enter the following described premises, 23652 Mats Drive, Brownstown, and do not have any contact with AJ Kelvin. Why were you returning there at 2 a.m. though?
Because prior to this, like the reason why I was living with him is because I told him my car almost died. I don't have a vehicle, so I have to go by, whoever that's around me who has a vehicle that's able to take.
Did he have any other contact with you after May the 10th up to today's date, other than on May the 15th?
No.
Your Honor, if I may, continue. Did he text you at all prior or after that day?
After what day?
After May 15th?
He texted me on May 15th.
What does the text say?
He sent me $103 and said, "This is all I have in my Uber account, is gone."
And for the record, this text screenshot was shared with defense.
This text happened while I was in the house.
And so following that day, did you leave that home was it in Brownstown Township?
Yeah.
And
Can I ask a question? I don't want to take the wind out of your sails here. Did anything else occur? Any other texts? Any other time he called you, saw you, emailed you, phoned you, whatever you want to call it, or came to your house, or came to your work, or came any place else after May the 10th, other than the contact you had on the 15th and the text message that you just described that he sent you?
Eric called CPS on me.
All right, well, that's a different issue. Did he?
He hasn't had direct contact with me, but he called CPS on me. And then after that, the police had showed up to my house with disturbing calls about my son. Which was also there in the report. I had lied to Eric and told him that my son was in truancy. My son is a pre-K student. He's part of GSRB.
Any other contact you had with him?
He told them that my son was in truancy, not going to school, that I was doing drugs with him.
Okay, I get it, but he made a complaint with CPS, right?
Yeah.
He didn't say this directly to you, any of this, right?
No.
Okay, I don't consider that to be a bond violation.
that's considered indirect contact, and this is a form of intimidation and harassment. And Your Honor, for the record, her testimony is completed if I could. Would you still like to have her testify or invite me to do an argument?
Well, I think the defense gets an opportunity to cross her.
So
Why-
they're not, I apologize for interrupting.
It's okay.
I'm just going to ask a couple more questions, Your Honor.
Take your time.
Currently, what city are you living in?
The state Linton.
To your knowledge, are you aware of if the defendant knows where you live?
Yes.
How?
He took my lease.
When you
And
say lease, what do you mean?
so when I smacked that pole and totaled my car, Eric came and got me from the hospital. And I signed my lease. After that, he took me to sign my lease, my contracts and speech.
Do you mean a leasing agreement?
Yeah,
Okay, so to your knowledge, did he ever have possession of that? To your knowledge?
yeah, he told me that he took it.
And, did you receive a visit from CPS following May 15th?
Yes, after the court date, a few days after that, CPS showed up at my,
Did you ever have any type of police contact at this point as well?
no. Oh, yeah,
Did the
Yeah.
police arrive to your house?
they came to my house like 3 or 4 times that evening after CPS showed up with disturbing allegations.
Now, to your knowledge, if you recall, do you know why the police showed up?
The police told me that there was disturbing allegations that I was consuming marijuana with my son.
And, currently, is that an issue for your leasing agreement, if you're aware?
So, yeah, before I moved into this leasing, the place that I moved into, they were under other management. They've had instances where someone's team,
Who's on the lease?
I just,
So is it?
Wait a minute, wait. I think I heard something differently last week, did I not? Who is on, were you leasing this with this gentleman, this property?
no, I was living there.
Your Honor.
Wait a minute.
I think there's some confusion.
Yeah, there's a lot of confusion.
So there's the home in question that they were initially both living in. She has now moved out and she's in a home in Lansing.
Okay,
And so the lease agreement that she's speaking about is for this new home in Lansing.
okay, why are we talking about the new home in Lansing and our lease agreement?
Your Honor, because of the indirect contact that was made by the police and CPS.
Okay, but he made an allegation with CPS, right?
To our knowledge.
Now, I don't know that this, now he might have other issues, but I don't know that that's going to amount to a violation of the no contact. Is the CPS investigation closed?
No.
Well, they might wait. I don't want us to talk about the CPS investigation. Under no circumstance would I suggest or order somebody not to make a complaint with CPS if valid. And the investigation is still ongoing, but here's the simple fact. He violated the no contact provision by going back there on May the 15th when magistrate or Judge Boyer told him not to. And he violated the no contact provision by texting this young lady on the date that she indicated. We don't need to talk about CPS.
I have no further.
Do you have questions of her?
Yes, please. When the May 15th, and you see the text from Mr. Rich Johnson, did you contact him previous to that?
Did I call Eric prior to that?
Yes.
No, I think I called him after.
And often? Your Honor, if I showed you something, would it refresh your memory?
What is that?
This is a message.
Text message?
Yeah, it's a phone call.
Okay, you can approach and show. Okay.
Thank you. This is refresh your memory?
Take a look at that real carefully.
That's my number. So the call happened before that, I did. Oh, no, I think that's the 15th. That might be the day.
And this is your telephone number? Yes.
Yeah.
Okay, and this is dated on May 15th?
Yes.
And the time says 7:46 PM?
Yes.
Okay.
What time did he text you? Before or after that?
That was I called them, so it was the same day after that I called him.
And he already texted you before you called him.
Yeah, he texted me while I was there at the house.
And then you called him after that.
Yes.
Good, go ahead.
You're saying he texted you before he made his phone call? Okay. And the text that you were talking, the only text you received earlier was the one from him sending you money, correct?
Yes.
Okay. And when you called him, did you ask him for money?
Yes.
Okay. Now, the lease that you're talking about is in Lansing. How long have you lived in Lansing?
I lived in Lansing for the past, I think, 3 years.
Okay. So, and your lease was on May 8th of 2026, your name's still on a lease in Lansing. Right?
I think it was before that. When I totaled my car, he picked me up from the hospital, he took me to sign my lease. And then the lease was in the car and I didn't see it get out.
But on May 8th of 2026, you had your own residence, correct?
Yes.
In Lansing.
Yes.
And
Had you ever lived with him or you just had a dating
I
relationship?
we were living together after I totaled my vehicle.
And when did you total your vehicle?
I totaled my vehicle on.
Just roughly what month, man?
I'm sorry, a lot has happened since then.
Was it more than 2 months ago that you totaled your
Yeah,
car?
it's been like
Then we don't need to talk about it. If you were living with him,
March 22nd.
okay, all right. And you were living with him until then?
Yeah,
Until March 22nd of this,
oh no, March 22nd, I started like living.
but you still had your place in Lansing?
No. I signed my lease March
All right,
20. I was released from the hospital and he took me to sign my lease. I was staying in a hotel prior to that, and then I hit that pole. I was coming out there to see him, and I had hit the pole, and he had came and got me, and we were staying with each other ever since.
okay, good on you.
And Ms. Calvin, your name is not on the lease, at the residence that were in question on this case, correct?
No, it's not.
On Mance Drive, your name is not on the lease, correct?
And you actually, when they arrested, Mr. Lloyd Johnson, you actually received a ticket that day, is that correct?
No, I didn't.
The police didn't talk to you about a ticket?
They didn't give me a ticket because Eric.
So, yes or no, did they give you a ticket for?
Your Honor, I'm
No.
gonna object to this question. I don't think it's relevant when she received a ticket for this, car accident.
Yeah, it's not.
It's not.
I'll sustain
Trespassing. I was trespassed from the residence when they arrested me.
Okay, okay. I don't think we need to hear any more. I get what you just said.
Right, and I'm gonna go back to one more question. You said that on May 15th, you received a text message from Mr. Woods Johnson. Before the one that you received at 2 later in the evening, correct? Because you called him and asked him for money.
No, so when I went into the residence and he was in there, sleep on the couch and all of my things were gone. I said, where are my things? He said that all of my things were gone.
Do you have a text message from May 15th before 7:46 p.m. from? No. Thank you. No further questions.
So you said before that you called him after he texted you, correct?
Yeah, that call that he had was after he texted me.
And it seems like it just contradicted your testimony. What time is that? 7:40?
7:46, Your Honor.
The text messages that he sent me, the money happened at 2 a.m. That happened at 7 in the evening that same day.
I see. Okay.
And just to clarify, you do not have a text message before 7:46 p.m. on May 15th.
I do the morning text message when he sent me the money.
On the 15th. That's it.
That's the way. And then I made that call around 7 o'clock that same day.
It's in the evening. So that was like
Hours later.
12, 17 hours later, right?
No, because it happened, I seen him at the house at 2 a.m. and then I called him in the evening time at 7. Because when I was in the home and I asked him where my things were and didn't get rid of my things, he told me that he went through them and took the things that he wanted to his mother's house and he got rid of all the other things. I called him at 7.
Okay, wait, there's no questions though right now. Just wait 1 second.
Okay.
Is fine. When you were living with Mr. Woods Johnson, it was his residence, correct? Were you contributing to that residence?
Wait a minute, wait, gotta answer out loud. When we're living with him, it was his residence, right? And were you contributing to financially toward food or anything else? You were?
Yes. When you were home at the time?
No.
So when you called at 7:46 on May 15, 2026, did you ask Mr. Johnson for money?
Yeah, I asked him to
Okay,
return
thank
money.
you. Thank you.
Any redirect?
The last thing was that you asked him to return the money. What do you mean by that?
So basically, Eric. So when me and Eric were getting into it, a police officer the day that he punched me told him that he could, because we lived there together, because I had established residency, that he could destroy my things. He can take my things and do what he wanted with my things, and there was nothing that I can do about it. That it was a quote unquote civil matter.
Let me stop you there. You said return the money. What did you mean by that?
He took my lease, and my son's money was in that envelope. It was in the manila envelope with my lease.
And so I had asked about.
Your Honor, objection, she's talking about things that are relevant to this case.
Yeah, why are we talking?
Your Honor, she had such the reason why she asked you for money, but you not phone call.
Uh,
I can move on.
You think?
And so you indicated you were living at the Nats Drive residence. Is that correct?
Yes.
And did you start living there somewhere around between March 22nd and March 26th?
Yeah.
And did you sleep there?
Yes.
Like almost every night following that day?
Yes.
And did you have clothing there?
Yes.
Did you and your son live there together with the defendant? And did you indicate that you moved out sometime around Mother's Day in May of 2026?
I didn't move out. I packed all of my things and put them by the door because I was under the impression that he was not allowed to return to the house but one time with the police escort. So when I packed my things and put them by the door, I didn't think the police were going to allow him to take them when he returned. I didn't know he was just going to come back when he was released.
I have no further questions, Trevor.
Anything else?
I do have one.
Just
Business defense concern. Excuse me 1 second. One question, there's not a date on here. Did you talked about a blackout, correct?
Yeah.
And did you make a report to the Brownstown Police Station with that?
Yes.
Your Honor, I would ask that, there's information here I would like to call Detective Ricard. As
for what?
Because at that time, I think
Oh, is this germane to the bond violation? All right, now I have Saev Qureshi. Is he here? This is 268-27912. Qureshi, your name, sir?
Saif Qureshi.
All right, so they can't do this. I'm dismissing this case on motion of the prosecutor. They can't charge a $10 conservation fee. So I'm going to go ahead and dismiss it. There's no costs, no fees. You are all set. Next time, don't fish without a license, okay? I know you got one now, but that's whatever. Good luck.
Okay, thank you.
Victor Matevsky, M680576. Where's Mr. Matevsky? You have to start your video and state your name, sir.
I think he's phone only, Judge, because he's pulled over in a truck.
Mr. Matevsky, where are you, sir?
It looks like he's logged in on a device now. I just can't get him to start his video.
You got to start your video, Mr. Matevsky. Come on. We got a lot of
Judge,
people in here now.
Judge, I think he called in. I don't think he has a video capability. He's the phone.
Can you hear what I'm saying, Mr. Matevsky? How am I supposed to communicate with people?
Now he's coming in on another device. Let me try that one.
Mr. Patevsky, can you hear us?
Yes, I can hear you now.
Your name?
Victor Mitevsky.
All right. You're pulled over, right?
Yes, sir.
This is a operating while texting, prohibited holding or using a mobile device while operating a commercial vehicle. Did they offer you anything, Mr. Kazmarek?
No, Judge. It was no offer.
No.
Just plea or formal hearing.
Okay. Are you guys? Is that what you want? Is that what you want as a formal hearing? I'm asking you guys, Mr. Matevsky, do you want a formal hearing?
Yes, sir.
Okay. Okay. You realize you're not going to do this in your truck. You're coming here, right?
Of course.
Okay. Good enough.
At this point, though, he does want me to withdraw. I would do it verbal motion withdraw. He wants to send the formal hearing on his own without attorney.
Is that true?
Yes, sir.
You wish to fire
sir.
Mr. Kazmarek?
And to show up to present myself.
I understand, but I just want to make sure I understand. You wish to terminate Mr. Kazmarek?
Yes, Your Honor.
And has there been a breakdown in the attorney-client relationship, do you feel, Mr. Kazmarek?
Yes, Judge.
I'll just make a note. Would you please send me an order allowing withdrawal
I will do that.
as this attorney of record, please? Will you do that today?
I will get it done. Yes.
All right. I'll just make a note of that. Order allowing withdrawal. Now, when do you want to do this? Can we do this in a week, Lisa, or wait a minute?
June 9th at 9:15.
June the 9th at 9:15. Okay, Mr. Matevsky?
Yes, Your Honor.
So you're going to be here in person. You understand that, right?
Yes, clearly.
All right. You're all set. Thanks, Mr. Kazmarek. Nice to see you. Take care, gentlemen.
You too. Take care.
People against Alexander Wilkins Alexander III. 26M665-269 A and B.
Good morning, Judge and staff. John Roxanne, appearing on behalf of Wilkins Alexander. To my left, please identify yourself, sir. Judge, there's one little hoop that this gentleman's got to go through, and that's his road test because he's been licensed for so long. Presented evidence that he's brought, the snuff on everything else, sir. I can't even communicate.
Who's out there?
It's the jail. I muted them.
I see. All right. He was arraigned March 31, April 31.
We're seeking a 2-week adjournment, Judge.
I'm not going to give you another one though, okay? I think I told you that last time, but I'll do it one more time. But if it doesn't resolve by the next date, we're going to have to set a jury trial date. I almost feel like we should do it now.
Judge, there's not going to have to be a jury or bench trial.
All right, I'm going to do it June the 9th on this one too, Lisa. We'll do this at 8:30. Is that good?
That's good. Thank you, Judge.
So, sir, June the 9th at 8:30. So get your work done so we don't have to adjourn it again. I can't keep adjourning this, okay? All right, you can go down the hall, get your paper notice, and you're all set. Good luck to you, sir. Thank you. Mr. Mahana, good morning. Did you already meet with the prosecutor?
Good morning, Judge. Yeah, I've spoken to the prosecutor. We have an exam that was set at 10. I'm still stuck at the Criminal Justice Center. It's my understanding that they don't have a witness.
Well, let me call them in. What are you doing on yours?
Holding.
All right. Tell her to come in with Mr. Mahana's, will you? I mean, you gotta be here in person for exams, though. I hope you're not gonna make a habit of this.
Judge, I'm not, as I told you, I am stuck
I
at
know,
the.
but I'm just telling you, you were supposed to be here at 10, were you, or not?
I was, Judge,
I'm just telling you,
unfortunately.
you can't be calling in at 11 o'clock for a 10 o'clock exam when you're supposed to be here in person. I don't need to fight with you.
I hear
I'm
you.
not gonna have that happen here, okay?
Okay, Judge.
Let me get her in here, and if that's the case, and she's gonna not only process or what have you,
Who do you need, Nora?
I don't know. Is it Ms. Esmaro or
No, Nora.
Nora Alloway?
And my client should be. I think
Where is
he's
your
in the-
client?
He's at the courthouse.
Right here, Your Honor.
Okay.
The judge needs you in there. Very- One second.
All right.
Yes.
Matthew Leone. Matthew Blake Leone, 26G710217. All right, sir, come on up here, state your name.
Matthew Blake Leone. In the Confronts, on behalf of Mr. Leone.
We're gonna just adjourn this another time.
That's correct, Judge. We're close to our.
Good enough. June the 9th at 8:30. How's that? Is
Thank
that
you, Judge.
okay? Thank you. Mr. Mahana's file, counsel, where is it?
I'm sorry.
I don't know who he's got again, who this,
Dalton Parrott.
Yeah, that's scheduled for examination.
he's saying that your witness didn't show up or something. So what are you gonna do with that?
You're on the not proceed. I'm going to do this
Hand that one up and I'll take care of it.
here.
People against, what'd you write on here?
I
People, that's all right. Dalton James Parrott, 26T710092. Everybody's name.
good morning, Your Honor. People pay 6528.
Good morning, Your Honor. Nijad- I'm sorry.
Good, good.
Good morning, Your Honor. Nijad Mihan appearing on behalf of Mr. Dalton Parrott, P59371.
Your name.
Dalton James Parrott, Your Honor.
So what is the status here?
Your Honor, the complainant inside here, we did set out subpoenas, myself and the officer in charge. Our office is on my contact. I think the complainant.
Can you write that on this stipulation, please?
No, at this time, we cannot proceed. I didn't write anything. I was withdrawing.
I understand. So you sent out subpoenas, you're talking about the victim is Merrill?
Correct, Your Honor.
She did not appear. She's not cooperating, correct?
To my knowledge, we have not had any contact.
Okay, so you're gonna write all that on the stip form. And then defense moves to dismiss.
Yes, please.
All right, case dismissed. Victim did not appear, not cooperating. Thank you. And I will go ahead and dismiss the case. And sir, we are going to take the bond conditions here out. So Lisa, make sure you do that, please, okay? Thank you very much. Good
you.
luck.
Have a good day.
Thanks. Thank you. All right, what else do I have? Which one's yours again, counsel?
Alex.
Who is your, who is the, prosecutor on that?
Not this young lady, this was, Nora.
Okay, you ready to go on Haddix?
Just two more for you on the record. One of them, I don't have a file for Robert Briscoe, it was on Judge Hessen's docket. I don't think this one was adjourned.
Hang on, you guys. Robert Briscoe is on Judge Hessen's docket?
It was, yeah.
Yes.
Cases, but the prosecutor review that was this morning, Michael Ianni, we went forward with that one, that one was on her docket, and then I didn't get anything saying we're, adjourning Robert Briscoe unless we are.
Did anybody
No.
adjourn that? Nobody
No,
adjourned it?
we left some things on her docket. It's a PCC.
We're just adjourning it 1 week to consider an offer, and then, we'll probably set the exam the week after.
Well, give me the file if you would. Where's Robert
John,
Briscoe?
did you grab Judge Hessen's files?
I did not. I wasn't aware that we were doing them.
They might
so-
still be down here then.
I do have Denisha Mendez, which is gonna be the same thing as your one we have filed that, that's on your
I'll
document.
grab those files, Judge. I was aware.
We just wait for you to file for this one. Yeah, okay. And then I have the Keith Haddix file, I've already not one.
Yeah, they're gonna go, right?
And then
Okay. Who's on this one? This is Denisha Charmaine Mendez, 26W7100. Wait a minute. This is Denisha Mendez. I think you wrote the wrong case number. It's two. What in the world is going on here? Is this the home invasion?
yeah, it should be Mendez.
Well, you wrote a 26 case number on here. It's 25B727912F. That's okay. 91F9152FY. Okay.
I'm sorry about that.
That's okay. I just didn't know. All right, Mr. Dox, your appearance.
Yes, good morning, Your Honor. Your great staff, Attorney Quentin Dox. My P number is
You're not moving
79657.
in that car, though, are you?
I'm sorry, Your Honor.
You're not moving in that car, are you?
Of course not, Your Honor. I do know your no, never would do that.
Okay. And where is Ms. Mendez? There you are, ma'am.
He's on Zoom, Your Honor.
Ma'am, your name?
Denicia Mendez.
All right, so we're going to adjourn this one more week. Is that right?
Yeah, and this is the first PCC, Your Honor, and we have a resolution. I just need to speak with my client, possible resolution. I just need to speak with my client regarding and keep it in district court.
Ma'am, do you understand that you have the right to a preliminary exam within 7 days of the date of the probable cause conference? Your lawyer wants to adjourn the probable cause conference. That means we will not have the exam within 7 days of the date of the probable cause conference. I'm going to set these for June 2nd and June 9th respectively. Do you understand that?
Yes.
That's if you waive that right. Do you waive that right?
Yes.
All right. Waivers accepted. June 2nd at
8:30,
and June 9th at
11.
11. Okay, so I'm gonna hope you guys do whatever you're gonna do next week, and if not, we go to the exam the following week, okay? So June 2nd, PCC, 8:30, preliminary exam, June 9th at 11 o'clock, okay?
Thank you.
Thank you very much. Good luck. Thanks, Mr. Dux.
And
All
Your
right.
Honor, I believe you have one more in your honorable court, Mr. Briscoe. I think that's just
That's the one we just sent down to Judge Hessen's.
okay.
That goes with that.
Okay. People against Briscoe, Robert James Briscoe, 24T7002091.
Good morning again, Your Honor, and great staff, Attorney Quentin Dox, P number 79657, on behalf of my client, Mr. James Briscoe, Your Honor.
All right. And where is he? Where's Mr. Briscoe?
Your Honor, I believe he's in the Wayne County Jail.
Is that you? Is this Mr. Briscoe? No.
No, sir.
Well, where's Mr. Briscoe at, Lisa? Do you know?
I have not seen him log in yet.
did they order a writ on?
Set for noon.
Yes. Let me
Oh,
look and see if he's still there.
It's set for 12 minutes.
Yeah, it's set for 12 o'clock.
Yeah, you're gonna have to zoom back in, Mr. Docs, okay, at noon?
I sure will, Your Honor. Thank you.
Right, thank you.
Just before, Senate Thursday adjourned it to, I believe 6-9. There was an email, I think, I believe Lisa was sending emails to us about that or Amy. I have to check, but we adjourned this one to 6-9. It just was not on record. And the attorney and I both, responded to the email to adjourn this case.
Wait a minute, is the lawyer here?
No, but we were in an email chain and I can pull the email chain that we were.
Let me see that. Let me see
Is that
the
Kenneth
file.
Hurd?
Yeah.
Yeah, we're adjourning that one. It just didn't get pulled. He was an exam judge, so we pulled it and moved it of Judge Hessens.
Okay, hang on. Let me call the case and then you put everything on record. Wow, this thing's been going on, hasn't it? This is Kenneth Robinson Hurd, 22B725431FY.
Morning, Your Honor, not sitting on behalf of people be 193.
He's in federal prison and we've had some trouble with Zoom. So it's been adjourned a few times.
So wait a minute, I just need to clarify. So he's not on, they had him, we sent notice and the federal prison doesn't have him in there?
No, we adjourned it. The file did not get pulled.
Okay, so I'm just gonna adjourn this. Did you say 1 week? Is that what I'm doing, Ms. Osmaro? Can you tell me your name?
Of course, I can't have the people be 8893. And what I have in the email chain is that it was going to be adjourned. Yeah.
Okay, and Judge Hessen knows about this, Lisa?
Yes. Yeah, she asked that we adjourn that one because it was an exam.
Well, how are they gonna do it at 11 a.m.?
And Judge, I believe the defendant.
Am I gone that day, something? Is that what's going on? How they
No.
setting it, how they setting it at 11 o'clock in the morning?
Yeah, we'll have to move it to 1 o'clock because it's hers.
Specifically, the attorney and his client did consent to being on Zoom instead of him being brought in. And then also we're most likely going to resolve this case. I talked to the very resident, and the defense attorney knows about this because I talked to him on the phone about it. And we're likely going to end up resolving this case because he's in federal custody. He has other cases and from 2023 all the way through McCollum, Oakland, and Wayne. So and they brought a case against him for all his 2023 cases.
It's fine. We're just gonna have to make it at 1 o'clock. Okay, so you'll be in front of Judge Hessen at 1 o'clock on June the 9th. Okay? All right, good enough. What else do I have? Anything else I need to worry about before I start this exam?
Well, a few more things. So Michael Blandy was technically set for motion and or PCC.
Is that in front of me or Judge Hessen?
That was Judge Hessen's case. I don't have the fund for that one, but that's another one that we.
Did you get Michael Blandy?
I gave all the files from.
It's not on
What's the last name? I can look it up.
It was Michael Blanding. It's that one aggravated stalking case. We had it and then we adjourned it a couple weeks ago. The attorney wanted to file a motion.
That one got moved
Yeah, do you know what day?
to June 2nd at 1 o'clock.
Okay.
So I don't need to worry about that. Okay, what else do you have in your hand there?
No, Parkhurst, I believe was a sentencing, first day that one, so I don't know if you can do that.
Parker?
Parkhurst, Scott Parkhurst.
Parkhurst is a pretrial. That's of Judge Hessens. It's still on the docket.
Okay, this is Morse case, so I have the file, I think Graziani's on it, so they can deal with that, and then the last one I have Robert Hicks, it's just a LAS ticket, I don't have anyone on it.
Is that my case?
It's, I believe it's Judge Hessens as well. And I got handed on.
I'm confused. Just hand those files up, will you?
It is, Robert Hicks.
It's at 1 p.m. That's a 1 p.m.
Yeah.
Well, are you gonna be here in the afternoon for any reason?
I have to be.
But this one's being adjourned? I don't know
No,
what,
I know,
Okay.
I've given everybody dockets. If it's on the docket, it's still going. I'm not sure where all the confusion is coming in.
is that still on the docket today
Yes.
for 1 o'clock?
Yes, it's on the docket because Judge
So-
Hessen would normally have the afternoon.
Yeah, so I'm still gonna handle it at 1 o'clock, I guess. Unless she's zooming, I don't know what. Wait a minute, you guys, listen to me. Let me see
Just
what you got.
just send her down here with all those files.
Yeah, you go talk to her and then I'll be glad to accommodate if I can.
Okay.
At least if there's any question, just let me know, will you please? What happened to all the other exams I had up today? I thought I had 6 exams up. No?
You adjourned one today, and then one on Friday got adjourned.
The 2 conflict cases, we know about.
Okay, wait 1 second here for 1 second.
Dismiss.
Did I
When
ever,
this,
did I ever adjourn Briscoe? Oh, no, he's coming back with Doc. Doc's is coming back at 12. I'm not.
yeah,
gonna
12
worry about
o'clock.
it. Right, I'm not gonna worry about that now. I'm gonna go on to this exam. Do I have all my other exams done?
I believe
One was a dismissal, one bound over, one was adjourned. And so you have Haddocks left.
All right, people against, you ready to go?
Already, did you want me to go check in with Lisa before, or do you want me to do that after?
I think after.
And then I'll just keep the files over.
Okay. People against Keith James Haddocks, 26W710099. Your appearance, Ms. Esmaro.
Good morning, Your Honor. I'm asking the on behalf of the PPP 8893.
Good morning, Your Honor. Good morning to your staff. May I please report Clint Castile, B697011.
Good morning.
Hearing on behalf of Mr. Keith Haddix, present, to my right, state your name for the board.
Good morning, Your Honor. Keith James Haddix III.
Good morning to you, sir. All right, so today I have Lieutenant Toller over here, correct?
Yes.
All right, so can you tell me your name, Lieutenant?
Lieutenant David Toller, what do you?
All right, so we're gonna go to exam on this, I've been told. The charges are felonious assault and assault or assault and battery. We're proceeding only on the felonious assault with a motor vehicle on the exam. If defendant is bound over, the assault or assault and battery will accompany that to the Wayne County Circuit Court. Any preliminary matters, Mrs. Morrow?
No, Your Honor.
Mr. Kesto?
Just the sequestration order, although I don't think there's only witness, I'd imagine, right?
One witness, Your Honor, just an exception to the officer in charge.
Yeah, the officer in charge can remain. All other witnesses, with the exception of the officer in charge and the defendant, are to leave the courtroom immediately. For the record, there's nobody else in the pews back there, the gallery. So with that, I will go ahead and ask you to call your first witness.
Thank you, Your Honor. People call Zachary and John.
Okay,
Would you like me to go with that?
please. Come on right up here, sir, to the witness chair, please. I'm going to ask you to raise your right hand. You solemnly swear or affirm that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yes.
All right, have a seat there. Have you ever testified before?
No, sir.
Yeah, I'm going to ask you to just keep up your voice nice and loud, and you cannot answer with simple mm-hs or uh-hs or nodding your head side to side or up and down. We have to verbalize everything, okay?
Yes, sir.
All right, you can proceed.
Thank you, Your Honor. And good morning, Mr. Andronic. Mr. Andronic, I want to take you back to May 1st, 2026. Do you remember that day?
Yes.
And on that day, were you at near 23555 Allen Road?
Yes.
And is that in the city of Woodhaven, County of Wayne?
Yes.
Could you tell us what's at that location?
Target.
Okay, and did something happen at that Target that brings you into blood today?
Yes.
Okay, brief description, what happened?
Well, I was pulling into a parking spot that the defendant was pulling forward out of. I had pulled in my parking spot. He threw his hands up. I threw mine.
Could I stop you right there?
Yes, ma'am.
If you take a look around in the portal, do you recognize anyone from that day?
Yes, sir.
Could you please point and identify on the portal clothing that individual is wearing?
What starts as a routine courtroom proceeding quickly turns into a serious examination of an alleged bond violation. Eric Woods Johnson is before the court facing charges that include felonious assault and domestic violence, but the immediate issue is whether he violated conditions of his release. Johnson's attorney tells the court that he is waiving his right to a preliminary examination, and the judge carefully explains what that decision means. The judge makes it clear that by giving up the preliminary exam, Johnson is giving up the opportunity for the prosecution to establish its case at that stage, and he will instead be bound over for further proceedings in Wayne County Circuit Court. Johnson confirms that he understands and that nobody is forcing him to waive that right. But then the tone changes. The judge turns directly to the alleged violation of conditional release. The court explains that a complaint alleging a bond violation can have serious consequences, including the possibility of taking someone into custody when the circumstances support it. However, the judge also makes an important distinction. In this particular situation, police apparently did not personally witness the alleged violation, and the judge questions whether the correct procedure was used. According to the court, when officers do not personally observe the violation and the defendant was not taken into custody, the allegation should be properly presented and supported on the record, rather than automatically treated as grounds for immediate detention. The judge then brings the complaining witness forward and has her sworn in. At first, the testimony is somewhat difficult to follow because there are conflicting dates and details. The witness discusses returning to the residence and seeing Johnson there, while the court repeatedly tries to narrow everything